Welcome to Tax Sale Insiders, the latest from tax sale resources, bringing you information about tax sales from experts in the industry. We interviewed Randy Saunders, partner at Nelson Mullins. Although Randy is based in Huntington, West Virginia, Nelson Mullins has offices all over the country and is one of the few firms with multi-state coverage focusing solely on tax lien and tax deed processes. So, Randy is back to talk to all of you about the Kentucky sales. There's a lot of good information you don't want to miss, especially if you wish to get into the Kentucky in a big way. So it's time to sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
Hi, everybody. Welcome to this episode of Tax Sale Insiders. We're lucky enough to have Randy Saunders with us again. Welcome, Randy. And Randy's from Nelson Mullins, which is, I guess, a group of attorneys. Randy, you can jump in and correct me here when I'm wrong, but they actually are rare in this industry in the fact that they provide, tax sale assistance, attorney assistance in multiple states from West Virginia, Kentucky, Alabama, I guess, Randy, I'll let you kind of elaborate on several other states, but typically, attorneys are very focused in a state. You guys are great because you can help in multiple states. And so we've chatted and talked about West Virginia. And today, I think we're going to focus on Kentucky. And you guys have done an excellent job of putting together these white papers. I know you have a copy of it there. You can show everybody. And it's always nice to kind of hear the same information, but, verbally, let me ask some questions and some clarifying, data and we can hopefully, make this, extremely useful for everybody, including myself, because I'm loosely, knowledgeable of Kentucky, but Kentucky is one of those states where it's so different compared to a lot of the popular states like Florida, Illinois, Arizona, that sort of thing, that it'll be as much of a learning exercise for me as it will for everyone else. So I guess, Randy, again, welcome. Thanks for joining us.
Thank you. And I appreciate having me again this morning. And I really enjoy speaking with you. And like you said, so Nelson Mullins, we have 25 offices nationwide. We have about 800 attorneys. And so one of the things we pride ourselves on is we really are a full service law firm in several areas, but especially from my focus in the tax lien area. If it's corporate issues, if it's funding issues, if it's servicing issues, if it's literally, I want to get into West Virginia, I want to get into Kentucky, I want to work with Matt Abey in South Carolina and Georgia and some of those states, if Alabama, wherever it might be, we can help you from inception to creation, corporate formation, funding. So we want to be kind of that full service partner that understands the industry, understands and sits down with you to kind of, what are your long-term goals and objectives, as you step into this state, and is this state right for you based on that? Like we talked about last time in West Virginia, you've got a smaller population, you've got 55 counties, and you're looking at a more focused kind of approach and more of a long-term strategy. And I'll get into this in a little bit, but Kentucky is a judicial sale state, so judicial foreclosure, and there's 120 counties. And I feel like for some, Kentucky can end up being a Vietnam if you go in and you literally try to lay down capital in 120 counties, and you try to deal with multiple judges in 120 counties and 120 master commissioners trying to get this for set. And by the time you're looking at it and you're trying to, service and deal with all of this, it can become a lot very quickly if you don't have a plan and you don't have that expertise. But a little bit about me, because like, why is a guy from West Virginia talking about Kentucky? I moved from Iowa to Kentucky when I was in middle school. I was graduated from what was formerly Muhlenberg South in the western coalfields. Went to Morehead State for undergrad, which is in the eastern part of the state, and then UK for law school. I've spent all of my career, practicing in West Virginia and Kentucky, and especially in the eastern states and across. If you take 64 across, you go through Louisville, Frankfort, Lexington, and then also down in the western coalfields where you've got places like Franklin, Simpson, and Bowling Green. And what you learn is it's a big state, and there's a lot of ground to cover. And again, I think that it is the second, in terms of the number of counties, it's the second largest, not obviously by land size, but by county size. And the reason for that is back in the day when they split it all up, they wanted it to be a single day's horse journey from wherever you lived to the county seat. And so that way you could get to the county seat, within one day. So that in my mind presents somewhat of a challenging problem that's a lot different than the state we talked about last time, West Virginia. But as you mentioned, we do white papers and work with you guys, and we appreciate the opportunity to work with you and get these out there. And this is on the site. It's called the Updated Comprehensive Guide to Understanding Kentucky Tax Sales. I'm going to use that kind of as a guide today and have more of a conversation with you. But this was published on April 1st of 2021. Obviously, things are changing. And this is a 20-page document, I think. But even that isn't enough this really just kind of gets you started with what we're dealing with. But so if we take a step back and we look at, what is Kentucky as far as the tax lien landscape, and it's a tax lien certificate or certificate of delinquency state, and they're sold annually at public auction. And so what happens is in Kentucky, taxes are due on December 31st, and they become delinquent on January 1st. And so basically from that period, we'll get into the time frames, but around April 15th is when you start to see the kind of available collateral as far as what I'll call, the tax liens start to line up what's going to be put onto the market. I think out of the gate, what's so different when you look at two states that are side by side, and you look at West Virginia, and you've got this state where it's 18 months and you get a tax deed and all this, and if you don't within 18 months, it's gone. Well, in Kentucky, it's entirely different. There's a statute that says you can get this, but you can't do anything with it for a year. If you are like most of my institutional clients and you buy at a certain range, and we'll talk about that in a minute, you also have an obligation to do a payment plan. So your servicing obligation in the state of Kentucky is a lot more significant than other states, because the state has made that, just from a public policy perspective, as one of its kind of main thrusts, that it wants to, I guess, and it's probably good from an optics standard too, because it shows, in our industry, I think so often, we try to explain, look, if we don't come in and pay this, it's the kids and the school boards and where all this tax money goes, that's where the shortfall is going to be. But as we know, it isn't always reported that way. When when you got the tax lien for a vet in Maryland or Michigan that was sold for 86 cents, or those are the stories we hear. So and I apologize, I went down that rabbit trail.
I guess they put the statutes in place to kind of help the constituents, right?
Yeah, and so what what they want to see is you have an obligation, and I'll talk about this more in depth, but essentially to get that payment plan in place, give them an opportunity to pay. You get the benefit of everything. Everything's added onto it. Your interest is 1% per month. Obviously 12% over the calendar year per annum. But that extra servicing obligation, and you don't have, if they fail it the first time, you don't have an obligation to do it again. And if you're not a big enough buyer, you don't have to, but you're not precluded from doing it. But then what happens is after year one, you jump in and you've got to go through the judicial foreclosure process. And so, there you've got essentially 10 years to bring the action. And so what's so different in West Virginia, we rarely run up against multiple liens on a property. But I've had, cases where it's sit around in the servicing portfolio for 8 years. No action has been taken for various reasons. And you've got 6 or 7 liens stacked up, that different parties have purchased. And we'll talk about how that comes into play too. And so, I think when you look at all these things and you think, just kind of giving an overview as we step in, if I'm going to step foot in Kentucky, I've got to realize I'm going to put this capital out. I can't do anything for a year. I'm going to have some servicing obligations, up front. We're talking about some notice letters and stuff like that. I'm going to need to, do the payment plan. But I also want to make sure that I do a little more due diligence up front, not only in selecting the counties that I want to operate in, but I want to talk to somebody knowledgeable local there, because you're going to be dealing with each county's judiciary. You're going to be dealing with each county's master commissioner. You're going to be, and so as you look and you say, and then also doing the due diligence to know, am I buying something that's been purchased 5 times, 6 times, 7 times? And there's, and so, because that's obviously, some of these properties, depending on the county and going on judicial sale, you're not really guaranteed how much they're going to bring, if anything. So all of these things kind of have to be factored in as you look at going in. Now, with all that being said, I do think because of the system that's set up in place, unlike in West Virginia, where you're looking and you're saying, I'm going to make my money potentially on developing a real estate portfolio. I can have my redemption money, I can sell property, and I can hold property. I think in Kentucky, when you look at it, what you're thinking is, I'm going to look at essentially a servicing model where I'm going to establish payment plans and I'm going to make my money on interest and redemption, more so than, because now you can show up and purchase at the judicial sale, but it's much more rare in Kentucky that my clients walk away with the property unless they really want it, than it is that this is, I don't want to say, well, we'll say primarily about capital as opposed to, acquisition of real property.
Well, I guess, Randy, a real quick question to help people understand because I understand what you're saying, but I don't know everybody listening. Well, when you say servicing and payment plans, I think in a lot of states that offer payment plans, that relationship of offering and managing that payment plan is typically done by the county, but in Kentucky, that's not the case, right? So when you say servicing, it's you are communicating with the taxpayer, you are setting up that payment plan, you're managing those payments, you're doing all of that. That's a lot more work than most tax lien investors are used to. Is that accurate?
Yes, and you get to add the grand total, unless it's changed since April, which I don't think it has, but of $8 per month in administrative costs for that. So that's not going to be your moneymaker. But what it does on a lot of these, because so I'll jump into this and then I'll jump back. But when we look at installment plans, so if you're going to buy more than 5 certificates statewide, or 3 in any county, or you're going to invest more than $10,000, then pursuant to the statute, which is KRS 134-128 and KRS 134-490, you have to have the monthly installment plan. And so the taxpayer and purchaser not only have to have those conversations, but you actually have to sign an agreement detailing the terms of the plan. And the purchaser there, again, it can say, but again, this is, you may impose the processing fee not to exceed $8 per month. But that's where, again, you want to make sure that you're getting advised by an attorney when you're making these agreements, making sure you're including that. So on the back end, because $8 a month's not a lot, but it ends up being, I'm not a mathlete, but what, $96, over the course of a year in addition. So it all adds up. And if you've got a portfolio that's large enough and you are servicing, let's say 1,000 of these, then you've got $8,000 a month on top of your services, so you can make it work. But I think you've got to do your volume calculations, and so it makes smaller portfolios a little bit less attractive than having a larger portfolio where you've got a dedicated servicing entity where you're doing, because we're going to talk about 45-day letters, 50-day letters, things like that you have to send out in addition to these payment plan communications. But you're right. You are managing, but you're essentially acting like a mortgage servicer, where you're taking the monthly payments until it's satisfied, and then that lien is released. And that's the other thing on the back end, making sure that you release the lien. But I think I said that, so if there's a default, they only get one payment plan. But at the same time, if there's a default for a reason that's acceptable, that's to the discretion of the servicer. You can make another payment plan if you're continuing to get paid on it. And then if you, and I'm not sure how many folks would get into the market and not purchase more than 5. So honestly, I think if you're listening to this and you're interested in getting into Kentucky, I think you need to be prepared for that payment plan servicing. And quite frankly, for anybody listening to this that's actually going to be invested, you're going to invest more than $10,000, or else you got to question if it's really a viable endeavor.
Now on that payment plan piece, Randy, is it very structured and because you're describing it, the other state that sounds somewhat similar is, and actually many listeners might disagree because most people don't know about this aspect of Texas. Texas has lien loans, I call them, totally separate from the standard, tax deed auctions that occur down in Texas, but you become a servicer of essentially micro loans, right? But at least in Texas, it's very wide open as far as how that payment plan is structured. Is it very cut and dry, like the payment plan is this, and the only interest you can charge is 1% a month, and the only fee you can charge is $8? Is it that structured, or is it pretty flexible and like, all right, if you make it 12%, 18%, is there a maximum and a minimum, and you provide, you offer whatever structure is best for you? How enclosed is that box of a structure that you have to offer?
Yeah, and so let me take it, because that's an interesting analogy that I really hadn't thought a lot about. But when you look at Texas and Nevada, they both have statutes in place which basically allow for these micro lenders to reach out to delinquent taxpayers before the issuance of the liens, and they'll pay on their behalf. And basically then they're assigned the lien from the counties, and then they're servicing, like you just said, and if they go delinquent, then that micro lender, what we'll call them, will have the ability to go after and foreclose just like they would if they would have purchased it. So the main difference, I think, there is the distinction of pre-sale and post-sale. And so I think there's more freedom of contracting on the Texas Nevada side, just because it really is a good faith transaction that's taking place before the sale. So these people are kind of negotiating to say, look, I'm willing to do this for you to pay my taxes and I'll pay you back. On the back end, you're in Kentucky, you're still you're not stuck, but you're still obligated to the statutory framework about what is recoverable. You can't contract for different terms, and you have to pay me this much more, you have to pay me in excess of the statutory interest rate, or more than the statute allows for recovery of fees. Because I'll tell you, that's one thing Kentucky does a good job. The statute outlines, what it believes reasonable attorney's fees are, the expenses that are recoverable, things like that. And so again, the agreement is more to provide the taxpayer with because this is not information that the public is normally going to be familiar with. So it's basically to put them on notice, and then you're inside. But the main difference being that you've got this signed agreement, you add in the additional $8, but that needs to be in the contractual provision. And then they're going to pay you monthly, and that monthly payment is going to reduce the overall obligation. And so And that's one thing, again, you've got to have a system set up in place so that if it's challenged and they say, I sent you these checks and they weren't applied, I mean, you kind of start getting into some of that. And again, that's not rocket science. It's just, you've got to make sure you've got it set up. And I think you have a significant volume so that, there's a big difference between having $8 a month and $8,000 a month,
right.
with the software and, the overall administrative support that you can have. But I think you at least need to have one or two people that are going to be dedicated to doing this, and then working with outside counsel to help you put together some of your letters and, managing issues as they come up. Because ultimately, at the end of the day, you're going to get the judicial foreclosure part if the payment plan falls through. And at that point, what you don't want to happen is for them to say, hey, you didn't do the 50-day letter right, or you've got a problem with this payment plan. So, you want to work cooperatively with your internal servicing folks. And I'll tell you, a lot of the stuff that we've done, we set up, like when I said, we're full service. So if somebody were to come in and say, look, I don't have the ability to, just create an in-house servicing department out of thin air. So, then they would contract with us and we would help and kind of help get the servicing and stuff like that. But most of the time, what I would recommend though is we don't accept the funds. So we would help set everything up, but they would still have to have an accounting arm separate where the funds go to the client for payment.
Okay. Well, real quick on the servicing piece, and then a couple questions on getting set up. So on the servicing itself, I guess that you're required, I'd say, to offer this payment plan. But if I know in a lot of cases, people don't pay their taxes, they don't want to be contacted, right? So you offer, and is there any requirement of offering it almost like a skip tracing or servicing, where you've got to go through XYZ and trying to find the person to offer that? Is that a requirement? And if you don't have any success, okay, the payment plan is off the table. Is that Yeah, and you want to, and that's well taken, because at the end of the day, again, that would be a challenge point when you get to the foreclosure part. Is hey, you didn't offer me this. You're supposed to offer. You can't foreclose on me until you offer me this. So you're going to want to go back and you want to be able to say, well, we sent to the physical address, certified mail, regular mail. The certified mail was refused. Return mail was sent back undelivered. Here's the information that we obtained from the PVA, which is in each county in Kentucky has a PVA, and that's where you go to get the addresses similar to our assessor and stuff in West Virginia. Okay. But you're going to want to have that all documented, so on the back end that you can show, because obviously you can't force them to take, and so you just want to make sure you can document the file when you get in front of that circuit court judge to say, here, judge. So when you get in front of the judge, because obviously that's the other thing you have to think about too. You've got 120 counties, you're going in front of a judge. I may be down there with 10 of these, and you've got to look at the sympathetic factor, and I can never fault a judge for that. He's looking at these folks that obviously had struggled to pay taxes, and they're going to maybe have some excuse. So you got to make sure that when you show that file to the court, that you can say, look, this is strict statutory compliance, judge. And so you can look through it. We did everything we were supposed to do. And, there's no reason to move forward. So it can take sympathy out, because if you can find something that demonstrates that we failed to strictly comply with the statute, more often than not, it's going to result in timely delays. And especially if you're in a position where you're not getting a payment plan, it's just sitting there, because then what you're going to come up against is year 2 and year 3. And what we jumped around a little bit, but if the bidding process in Kentucky is a little bit different, and it's a round robin process. But you basically, before, it's about 10 days before, I think you have to submit at least 10 days before.
any priority certificates, which would mean all, like, so you bought a bunch in 2020. Now you're coming to the 22 Round County where Morehead State is, or Fayette County where Lexington is, and you need to tell the clerk, I have priority on these and I intend to buy them again. Now, the difference is with that, you have to pay 100%, right, when you do that. Then you do a second list that says, I don't have priority on these properties. I haven't bought them before. So yeah, so if you've got your priority certificates, those are the ones that you've purchased in years past. You've got those. It's the deposit on those is 100%. Then you've got your list that you have to submit where you do not have a priority claim, but these are the new properties that you want to buy during that tax year. And so at that point, you have to provide a 25% deposit on the total value of those certificates. So you're going to get 100 certificates and they're $1,000 a piece, $100,000. So you got to pay your $25,000 deposit and provide that list. What happens though is when you go in, and I'm not sure, Brian, are you familiar? Are there round robin sales in some of the other states that you deal with?
There are not many. I think a couple that come to mind is Wyoming. And it's really sporadic on exactly how they conduct those round robin sales. So it's probably good to describe exactly how Kentucky does it.
Yeah, and that's one of the things I think when the internet bumped out there a little bit, is I always caution clients, because as the attorney, I don't spend a lot of time at the actual auction part and doing the bidding. Usually they've got folks there, they know what they're looking for. And so I'm going off of, statute, case law, things like that we read of how it's supposed to take place. But when you look at the round robin, the county clerk is going to have predetermined lot sizes. And it can start off just properties, it can start off in depending on the size of the county. I mean, you could have lots of 500 up to 7,500. But what's interesting?
Lot sizes and number of properties, number of liens.
Yeah, and so the issue is that this is statutory.
Mm-hmm.
So again, I can't think of a sale where you'd have a lot size of, I mean, that doesn't of 7,500 certificates. But it's so, and let me clarify that. You've got a county, so there you'd be talking about Jefferson, where Louisville is, or Fayette, Lexington. You've got I think I misspoke there. You have a total of 7,500 certificates.
Mm-hmm.
So from 2,500 to 7,500, there's going to be a lot size that they can do, but it's dependent on how big your county is to how your lot sizes are going to be divided up. Okay. And I misspoke there. You're not going to have 7,500 in the lot size. You're going to have counties that would have 2,500 to 7,500, and for those they can lots of no more than 50 for the first 4 rounds, and then all subsequent rounds they can be sold in lots not to exceed 2% of the total number of certificates. So as you look and as you go in, you're going to look at the total list, and that's going to determine in your smaller counties where there's fewer than 500, your lot size is going to be up to 5 for the first 4 rounds, all the way up to 50 like we talked about. But I think the most important, outside of the mechanics, because again, that's where I just don't spend a lot of time in these auctions for bidding. I think the most important thing that I tell purchasers is, in Kentucky, you really need to do your due diligence beforehand, because you are only eligible to select certificates that you included on your current year list that was submitted when you registered for the sale. So if you did not register beforehand for that property, you cannot purchase it at the sale.
So help me understand the connection with the lots versus what you're purchasing in the round robin. So they let's say the smaller county and they have a lot size of, and if Randy, if this is the part that you're not as familiar with, just let me know. But they have a lot size of 5 parcels. Is the county saying, hey, here's 5 parcels for sale in this lot, right? And then it's I'll say round robin, to whoever gets to buy it. I guess what I'm not sure about is, let's say you wanted to buy 4 of those 5 liens, or is it something where they break up the lot so that it's always, even? Does that make sense?
Yeah, and so that is where I don't, and I tell you, there's a manual, and it's at revenue.ky.gov, and it's under documents and potential third-party purchasers manual, and that's where I kind of go to get the overview. And so I think what I would do is start there, and then go and if somebody had a specific question going in and was saying, hey, look, Randy, I want these properties, I want to make sure these properties on the list, if this is part of this bundle, we could call the county specifically, and honestly, I think that's always a good idea, is just to call and verify, because again, outside of actually being there in that sale, that's probably the part I am most uncomfortable opining about.
Okay, and so we'll get that and send that manual out to everybody so they can reference that as well, Randy. Thanks for.
And there's a link, a hyperlink in our article. So if you look on page 7 of the article that's posted on your website,
Okay.
It's under subsection C, sale procedures. And so it's that link there.
Okay. Now it's I guess the other question I had, and if this falls in that bucket too, just let me know, is the the deposit amount that you have to put down is 100% of those that you have primary, meaning you've bought those liens in the past, and the secondary is only 25% of the amount, because these are liens that you haven't owned in the past, somebody else might, or nobody has, right? But you have interest in it. Is it kind of guaranteed that if it's a priority one that you own in the past and you identify this as one I want, do you automatically get that?
Yes.
Okay.
Yeah. So that's a very good question. So all priority certificates that are allocated to third-party purchasers are removed from the sale. And so again, when we're looking, we're doing our due diligence as the list, because if I jump back here, let me get the timeline for you. So on April 15th, or about 3 months and 15 days from the date that the delinquent taxes were due, if there's an alternative schedule, but let's just go by, it's January 1, so April 15th, the sheriff files all the tax claims. Real property tax claims become a certificate and go through the Department of Revenue. That's why we go to the Department of Revenue page as opposed to the sheriff. And so they're responsible for collecting. And what I think, when you look at when they start to pull out here, and I want to get my timeline, the Department of Revenue establishes the statewide schedule for sale of the certs in each county. So we go on the Department of Revenue site, we see when each sale is going to be. The sale is conducted by the county clerk, and it has to be scheduled 90 days, but not more than 135 days after the unpaid tax claims are filed in the county. So again, that's kind of starting to set up, and why this is important, and I know a lot of this is probably like, why is he saying all these numbers? But because you're going to start looking at what inventory there is, right? But what we don't know is there's just like in West Virginia, there's not as many buyers. In Kentucky, there's a larger number of institutional buyers. And so it's more likely that you're going to have more priority claims. So as you start to look at your inventory and you do your due diligence and you're starting to narrow down what you want, part of that list is going to shrink, because not only your priority claims, but everybody else's priority claims is going to be taken out of that list. So when you get to the sale, and unfortunately, you're going to submit your list and you're going to submit your 25% deposit on new certs that you want. But there's a good chance that everybody else at that same time is also filing their priority and their new certs. So some of the ones that you're listing, somebody else may have a priority on. Now, we can do the research on the front end and kind of see how many liens are stacked up and things like that. But it's kind of ever changing as what that inventory is going to look like, because again, the list of priority certs doesn't have to be submitted to the county until 10 days before the sale.
Okay.
So I mean, we're right on the doorstep. Yeah.
On those priority liens, you mentioned in some cases, right, you have to wait at least a year, but you had mentioned you're aware of some instances where there might be 8 years and 6 different cert holders.
Yeah.
Is there an, I'll say, uber priority where whoever has the oldest lien and identifies if they want to buy it, do they have first right, or is it swapped as in the most recent?
Most recent.
Okay,
It's
so
the most recent.
if you buy a lien and skip a year and somebody else buys that, it's that person that bought it under you, they have priority to get it first. So you don't want to just buy one and then hold it saying, I can come back in 5 years. You want to continue to buy that every year if it's available, obviously.
Right.
Got it. Okay.
Right. Yeah. So so let me kind of go back to that. So the statute says there's basically a tolling period for the first year. And then after that tolling period, you have 10 years to execute on that lien. So we always say 10 plus 1 or 11 total years, but you can't do anything during that first year. Mm-hmm. So so what happens is just like with some judgment liens and other types of liens that we would have experience with, at the end of that 10-year period following the first year, it will just fall off and it becomes unenforceable. And so it's you at any time after that first year, you can move to foreclose. You can continue to purchase and stack priority. And like you said, if you drop out and somebody else jumps in, then at all tax sales going forward, they're going to have the priority. And then what happens is when you file for judicial sale, everybody with an interest is going to be part of that and be paid out of the master commissioner's sale.
Got it.
But we'll get to kind of that point but so let me just go. So when you get the pre-notice of the tax sale, so it says at least 30 days, but not more than 45 days before the sale date. And remember, the sale date is going to be established by the Department of Revenue, but the county is going to be responsible for publishing in the newspaper 30 to 45 days before in each county the list. And so that's kind of that first part of trying to find that newspaper list, looking through and deciding, understanding that there's going to be some people that pay those taxes. There's going to be some people that are priority. There's going to, but that gives you your list. We talked about kind of the round robin sale. And then if we get into post-sale notices, this is now where the servicing obligation is a little bit heavier in Kentucky, and it's critically important.
So
because
sale notification, that's not the responsibility of the
no,
right, it's county. Okay.
That's the county clerk. He's going to put it in the newspaper, due process. Hey, you haven't paid your taxes, pay your taxes. But for us, we use that to look at inventory. For them, it's notice to go pay your taxes. For us, that's kind of our first opportunity to go and see what kind of inventory is available in each county. And so, you derive that list from the Department of Revenue sales schedule, and then you can just, based off that, extrapolate when those newspapers should be published. But it's going to be published in each county. And I'm telling you, so in Muhlenberg County, where I grew up, we had a newspaper that was published once a week. So I mean, you're not exactly sure when it's, but it has to be between that 30 and 45-day period. So then you've listed your certs that you want, and you come out and it's okay. What do we do next? So payment plan, we talked about and going down that road. But even before that, the delinquent taxpayer must work with the third party to satisfy the delinquency. There is an obligation that's put on them. So again, that's what we have to tell, that we can't burden shift, and we try to get the judges to understand that we're doing everything we can, but obviously we own the lien, and the taxpayer obviously has an obligation to work with us too. But within 50 days, and this is what we call the 50-day letter, after delivery of the cert, we have to send out notice to the delinquent taxpayer by first class mail, and you have to have proof of mailing. And so all of that's a little bit tedious, and it can be easy to look for instance, hey, yeah, we sent everything else out. Did you send it out? Registered mail, return receipt requested. Did you get that back? Did you keep that? Because when we go to court, I'm going to need all that. I'm going to need that 50-day letter. I'm going to need a copy of the envelope. I'm going to need a copy of the green card showing that it went out and it was received. The notice, it's very specific in the statute. Basically, that there's a lien against the property, 1% interest per month. If the cert is not paid, it will be subject to collection, which it will include foreclosure. A list of the total amount due as of the date of the notice. And again, that can be a little bit, you got to make sure that your calculations are correct there. And as far as what is the tax, what am I statutory allowed to send out to this taxpayer? But just like with anything else, they haven't. Kentucky has determined at this point they have a right to know the amount due, and that's basically going to be the starting point for everything else that is added on. Let's see. And then you're looking at discussing again the payment plan, or if they simply want to try to redeem, and who is eligible to redeem. One of the things we run into in Kentucky a lot is, you'll have a mortgage, servicer who will step in, and that is why a lot of times, especially if you're buying it, because again, taking a step back, in West Virginia, you don't want that mortgage servicer to be there if you want the property. You don't want them to send them and pay all your bills, right? But in Kentucky, when you're doing your upfront research, it's not a bad idea to have a mortgage servicer in the background who either is responsible to pay these taxes through escrow, or even if it's non-escrowed, that this is the only secured collateral they have against this loan. And so what you do is you can sit there, and that's why some of these liens sit there for 4 or 5 years, because they're accruing interest. And then at some point, when it goes to foreclosure, you're going to have that servicer show up and say, okay, we need to redeem this. And so it acts as so even if you have a taxpayer who cannot pay and has failed at the payment plan, if you have that in the background, that's an added layer potentially of security. And I'd say more times than not, they're going to show up and redeem. At least that's been our experience. Got it.
So it's kind of a hint for everybody listening, if you are looking to get in Kentucky. And it certainly sounds to me, Randy, as Kentucky's not a state you dabble in, right? There's
right.
There's homework not only from I'm assuming there's probably counties that are a little easier to work with than others. There's that homework, but then there's also a lot of setup that you need to put in place: notices, payment plan, documents, a software, a person that you probably need to help unless you want to do it yourself. You need to do all of that to really even get started in Kentucky. So it's not something you dabble in. And so if you're going to do it or enter the market in a large way, then that type of information is extremely valuable for everybody listening, which is mortgage holders will sit out there until you file foreclosure. So whether you want the property, maybe you want to do it after that first year. If you're just looking to gain some interest, maybe you let it sit for a little longer. So there's several different strategies, but having that piece of information is pretty key.
And if you go to the foreclosure sale, and let me just, let's kind of start there real quick. And I'm not sure how much time, but if we've got a little bit more time, if I can just go through the kind of initiation of the action and how that kind of plays out.
Yeah, let's. So real quick, just kind of summarize. Yes. You have to wait at least, is it a year and a day, or is it a year from the sale date?
So you can't institute anything during that first year. So yeah, essentially, the fair reading of the statute is it would be January 2nd. If we're saying that delinquent taxes accrue on January 1, then a year would be January. So January 2
Okay.
would be the first time you could in.
So it's not a year from the sale, right? The sale is typically in May-ish, right? May, June, somewhere in there. You don't have to wait a year from the sale. It's a year from the date of delinquency.
Let me go back and verify that.
I guess while you're looking at that, you don't have to do anything in after that first year. You have up to 10 additional, so 11 years, or is it
11 years total.
okay? And is that to start the foreclosure process or be done with it?
Yes, to start. Yeah, as long as an action is instituted. So you know, on the filing of the complaint. So you know, then you're moving forward, even if it's not served yet. But you know, for the most part, most of them don't sit around quite that long. You know, because then at some point there's a tipping point where the inherent risk of holding on to it just lessens the potential of any actual recovery.
Okay.
You know, so I think
There's that.
you know, a healthy portfolio probably is going to, you may have a few years stacking up, but I would, if you had somebody that was looking to purchase a portfolio, or you know, I would look closely at the age of the liens, and if especially say you see groupings of aged liens in certain counties, you got to ask yourself, why is that? You know, and maybe that's also a hint to you that that's not a very friendly venue for this industry. And so maybe we don't want to purchase in X, Y, and Z county. And there's a reason why they've got liens that are 7, 8, 9 years old in that county, you know, and it kind of telegraphs to, so yeah, depending on the number that you would see and the age, some of that starts to concern me a little bit. You know, we've had situations where there was a large number of liens that were invalidated in Eastern Kentucky counties, you know, for various reasons that were in portfolios and had been in portfolios for a long time. And so, but again, that's a little bit different
because they were over 11 years, or invalidated because they didn't follow some of that, whatever process is needed in the given timeline.
So one of the ones that I could think of was refuse fees were, instead of it being real property, they asserted a lien for unpaid refuse fees. And then they sold those liens, but they were sold by the county and they were very similar. Well, they all became, you know, essentially worthless down the road. And so again, you want to do your due diligence and make sure and see what you're purchasing.
Got it. So if somebody's selling a portfolio, sorry to jump around.
No.
If somebody's selling a portfolio of 11-year-old liens, let's say 11 years in a day or more, is that worthless paper at that point?
Not necessarily. Oh, yes. Yeah. 11 days. Yes. 11
like
years.
You could still set up a payment plan, and granted, you can't foreclose on it, but you could still, I'll say, lottery ticket, set up payment plans and collect something. Those are truly worthless certs at that point.
Yeah, I would be hesitant to advise anybody to try to collect it. And there may be more, and honestly, I off the top of my head don't know the court's position on that, but I would be very hesitant to advise anybody, even to try to. Obviously you can't institute an action and they're not going to be enforceable, but I would not advise my clients to even try to collect on something, because I think that you could very quickly run afoul. But what I would say, going back, if you've got a portfolio, even if it's a little bit older, you know, you can look at all those things we talked about, and you can look at the servicing file, you know, make sure that it has the letters that are required, that it has, you know, all the documentation, that's not the problem holding it up. You see if there are some with you know, mortgages out there, and you can look through it and determine. And that's one of the things we do. We help clients look through, in the states that we're most familiar with, look at the counties, understanding the dynamics within that county, understanding the age of the portfolio and potential problems, and then helping them potentially, you know, purchase that portfolio or pass on.
Okay. Now, I guess one last question, sale wise, and then you know, maybe we can dive into the foreclosure piece. So liens that are advertised as being available, nobody reserves them, nobody ends up buying them, they end up unsold, right, or struck off. There's lots of different names over the counter. Do people have the ability to buy those at any point in time after the sale, or are they basically unavailable until the next sale? They'll bring them up then, and I guess what happens to those?
They go and find, because that's not something, again, that we traditionally get involved in, the ones that aren't purchased.
And so, I guess we can leave it up to, I guess, investors that are maybe interested in that, reach out to the county, and maybe it varies by county, right?
Well, and I think that most of the time, and we've got a section that deals with that on page 13. There are public sales. So again, if you've got state-owned, county-owned, or taxing district-owned properties, and it's gone through the lien cert, and then it's become they have the ownership interest, they can advertise those. There's a statutory process for public notice and public sale. But again, those are ones, and maybe there's some, but vast majority of the time, there's a reason that those don't get picked up from what we see. I mean, there's, usually you have a pretty good, amount of buyers in Kentucky. And so where you're not leaving a lot of, what is it? The wheat and the chaff. It's most of the chaff that's left on the floor after the sale.
Got it. Well, Randy, I want to be cognizant of your time, because this has been awesome. And I feel like there's a lot more that we'll talk about on the foreclosure side. Could we maybe set up another call to talk about the foreclosure side?
Yeah, I'm happy to.
Okay. Well, then, we film these live for everybody that's watching, and I don't want to make this too long for everybody. Because Randy, this has been awesome. I want to have you back. We'll talk about the foreclosure aspect, because that's a very key component of Kentucky as well, especially because of the servicing aspect of it. So outside of the foreclosure, I got one last question for you.
Okay.
Outside of the foreclosure side, what would be your biggest recommendation for investors that are looking to get into Kentucky that they need to keep in mind?
So, and this is probably going to be a little bit of a convoluted answer, but I think when you look at Kentucky, Kentucky is a very, very old state that was part of Virginia. Land is very important, and it's passed down from generation to generation. And so while, everyone understands the importance of the delinquent taxes being paid, and I'm sure a lot of states are like this, but there is a very real attachment that people in West Virginia and people in Kentucky have to property. You have more family cemeteries on property in Kentucky than any other state, and I mean, small family plots. And so, I think that it's important to do the due diligence, to look at where you're going to be, to understand that local jurisdiction, the county, and understand that because of this attachment and because of the importance that property has to the people of Commonwealth, that when you go through your servicing and you move into that judicial foreclosure phase, you need to make sure that you've done everything so you can say I've purchased the tax lien to benefit the county. I've tried to work with this delinquent taxpayer so that they could have a payment plan. I have provided all the notices, and make it easy for the judge to say, okay, you've done everything you were supposed to do, because again, it's not just a rubber stamp. You've got to go through the judicial process, then you got to go over to the master commissioner and get it appraised and sold. So I think that sometimes, looking at counties, looking at what your long-term strategy is, and understanding the dynamics of those counties, and having counsel that's local and can guide you through that, it's important, because I think there's a lot of intangibles that can impact long-term success. And it just goes back to that importance of land and the apprehension to strip that land without providing every conceivable opportunity for that citizen of that county. And I told you that was probably going to be convoluted, but again, I think it goes back to, making sure that you know where you're buying, and you understand all the dynamics. You understand the judges, you understand the master commissioner, you understand your audience, and then you do everything you need to when you get into court, because a lot of times they're going to be looking for a reason fairly, to say, look, you haven't complied with the statute. And so I think you go in almost like in a football game, you're going in the fourth quarter and you're probably a little bit behind if the score is based on sentiment. Does that make sense?
Yeah.
And so you want to be able to say, I am a benefit to the Commonwealth of Kentucky. I'm a benefit to your county, and I do everything by the book, and I help your citizens, and build a reputation in that county, because that's going to be, if the more symbiotic the relationship can be, and the more that they understand that this is a benefit, you're here for the long term, you're working with the people, I think the more successful you're going to be. If you come in and you're unattached, unassociated, and it gets a reputation of it's being sloppy, or that the citizens of the county aren't being treated fairly, then you're going to set yourself, and a lot of times little things like that can harm your reputation. But I think you want to go in and make sure you're doing everything by the book to build your reputation.
Gotcha. So I guess you can do all that homework or learn that and somehow by yourself. I don't even know where you'd start. Or working with a group like Nelson Mullins and you, Randy, will have a lot of that knowledge from the get-go. And so if you are looking to jump into Kentucky in a big way, Randy, I know you won't say it, but I highly recommend giving Randy a call, and it'll be well worth the time and expense to have them help you at least do that homework and figure out what model works for you, because that is as important, or maybe even more important than the research of the properties themselves, it sounds like. Well, Randy, I greatly appreciate your time today. For all those that were hoping to get the soup to nuts today or in this video, sorry, we'll definitely circle back and go through the foreclosure process. I know that's very intensive in Kentucky as well, and so we'll make sure you guys get that information. But hopefully this has been as much of a learning experience for you all as it was for me. And Randy, again, I appreciate your time. Thank you very much.
No, thank you for having me. I really appreciate it. I look forward to circling back around on foreclosure.
Absolutely.